This week on Rochelle's Daily Wire Video Edition, we will visit two relatively obscure but actually rather important decisions involving bankruptcy law. First, let's go to the U.S. District Court in Manhattan, New York City. This is a case that involves the safe harbors in Section 546 of the Bankruptcy Code. As you know, that's the provision which says that a trustee may not sue financial institutions, commodity brokers, or swap participants except for actual fraud. Well, in this particular case, it wasn't a bankruptcy or a bankruptcy trustee. It was an assignment for the benefit of creditors. And in this ABC, as they're called, the assignee sued a swap participant in the federal district court in Manhattan. Of course, the swap participant turned right around and filed a motion to dismiss and said, no, you can't sue us because we are a swap participant protected by the safe harbor in Section 546G. The swap participant took the position that the assignment for the benefit of creditors was the functional equivalent of bankruptcy, and therefore there could be no lawsuit because the suit was not entirely for actual fraud. The district judge made short shrift of that argument. She said there was no federal preemption of state fraudulent transfer law because the plain language of the statute said that it only barred a trustee from bringing these suits. So she denied the motion to dismiss, thus for the time being allowing these constructive fraudulent transfer suits to go forward. I might add that this seems to be an interlocutory order, so I'm doubting there will be an appeal in the short run, unless, of course, the swap participant tries to get leave to have an interlocutory appeal. The second decision comes to us from the Ninth Circuit Court of Appeals, and this could be a biggie if it's adopted around the country. This decision has to do with standing to take an appeal in a bankruptcy case. Around the country, pretty much everybody believes, including the courts of appeal, that to have standing in a bankruptcy case, you must be a person aggrieved. Those words are in quote. To be a person aggrieved, it really means that you have to either win or lose, financially speaking, as a result of taking the appeal. Well, the Ninth Circuit told us in this opinion by Circuit Judge Nelson that that was the law, the statutory law under the Bankruptcy Act. But the Bankruptcy Act was repealed in 1978 with the adoption of the Bankruptcy Code. Judge Nelson went on to say that these days, the only standard for appeal is whether or not there is a constitutional standing or Article 3 standing, which means that it is a far lower standard because for constitutional standing, you only have to have a case or controversy. Now, as I said, this is a big deal because if there is a lower standard for appellate standing, it means that a lot of folks could bring appeals in bankruptcy cases who heretofore had been barred from taking appeals because they were not a person aggrieved. I'm Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. God willing, I will return same time next week with something interesting in the world of bankruptcy. Until then, be well, stay safe, and good day.